Be ready? Let's start. The appellant in this appeal was convicted for an offence punishable under sections 279 and 304A of the Indian Penal Code for causing the death of a 7-year-old girl on account of his rash and negligent driving of his tractor. Full stop. The appeal from the said order and conviction and sentence having been dismissed by the learned sessions judge, the appellant moved a revision before the High Court. Full stop. In revision, the Karnataka High Court, while confirming the conviction, set aside the sentence in respect of the offence punishable under section 279 of the Indian Penal Code, but maintained the conviction and sentence in respect of the offence under section 304A of the Indian Penal Code, whereby the appellant was sentenced to undergo simple imprisonment for 6 months and to pay a fine of rupees 2000, and in default of such payment, to undergo further simple imprisonment for 3 months and also to pay a fine of rupees 600 for the offence punishable under section 279 IPC, and in default of such payment to undergo simple imprisonment for a month. Full stop. Para. In this appeal, the appellant has challenged the order of conviction and sentence passed by the additional civil judge in Para Junior Division, Para out, and judicial magistrate, and the subsequent orders passed by the Sessions Court and the High Court maintaining the conviction under section 279 and 304A and the sentence in respect of the conviction under section 304A, IPC. Full stop. Para. During the hearing of this appeal at the admission stage, learned counsel for the appellant Madhukar, 2 cases under the Prevention of Corruption Act, 1988 were pending. Full stop. In one case, the said accused had offered bribe to the investigating officer and was caught red-handed. Full stop. It was submitted that considering the gravity of the offence, the sentences were directed to run consequently in terms of section 31st, in bracket 1 bracket out of code. Full stop. It was stated that the High Court was misled in the case of respondent Janki, who made a false statement before the High Court that he had deposited fine amount, while in fact he had not done so, as would be apparent from the second order. Full stop. It was essentially submitted that without indicating any plausible reason contemplated under section 389 of the code, the bail has been granted. Full stop. The seriousness of the allegations for which the accused respondents have been already convicted, has been completely lost sight of. Full stop. Para. Learned counsel for the respondents, on the other hand, submitted that the parameters for grant of bail and cancellation of bail are different. Full stop. It was submitted that some of them are very elderly persons and have retired from services. Full stop. It is not a case where any irrelevant factor has been taken into consideration. Full stop. It is pointed out on behalf of respondent Madhukar that the said accused is stated to have centers round 2 cheats, which were exhibited. Full stop. They did not in any way establish the involvement of the accused in the alleged crime. Full stop. That is why In his case, the High Court observed that the evidence is scanty. Full stop.